103 103 years ago, right where we stand today, bombs were dropped on a black community called Green. 103 years ago, an area, 40 blocks, over 11,000 individuals suffered through the worst domestic terrorism in the history of this country, now known as the Tulsa Race Massacre. And out of all of those thousands of victims who saw their neighbors killed, the homes burnt down, the valuable goods looted, the community ransacked, we have one survivor that's actually here with us today, and one other survivor that cannot be here today. I'm attorney Mario Solomon Simmons, along with my amazing team. We are proud to continue to represent was Senator Randall, who's 109 years old, who's here today, and Mother Viola Ford Fletcher, who's 110 years old and could not be here. We also had one of the daughters of Houston Ellis, Muriel Watson, who's here with us today. Mr. Ellis, as you know, Uncle Red, as we call him, passed away last October. We're here today because a couple of weeks ago, Oklahoma Supreme Court unjustly dismissed the appeal that we put forth in this matter. And my team and I, we're going to talk specifically about that appeal and petition for review. But before we do that, it's very important that we really understand the moment that we're in today and the history that got us here. I've already told you in 1921, this community was destroyed, burnt down by the defendants, the city of Tulsa, Tulsa Chamber, the Tulsa County, Oklahoma Military Department, National Guard, Tulsa Sheriff's Office. But also after the community was burnt down and over 10,000 people were made homeless, some up to 3,000 never heard from again, over $200 million in property damage alone. Thousands of people have intern camps as enslaved people, cleaning up their own community, and forced to only be able to leave that green badge signed out by a white employee. After that happened, no insurance payments, claims were paid, all denied. And on starting just the days after the massacre, you had lawsuits being brought by lawyers like the great B.C. Franklin. And all those lawsuits were dismissed. The courts failed us in 1921 when they let those lawsuits languish from 1921 to 1937 to dismiss them without giving them an actual trial on the merits. And then you fast forward the 75 years of the conspiracy of silence in the city of Tulsa, perpetrated on the massacre victims and this nation, only to be broken in 1997 when the state Tulsa Race Riot Commission put together to study the massacre riot, as they call it at the time. And that particular commission in 2001 stated specifically in a report that is a part of state law, Oklahoma state law, that said that reparations and repair was due to the survivors and descendants of the massacre. Many of these survivors you see on this wall as we stand here in the survivor hall who are alive, fighting for reparations. And these individuals are now deceased. Despite the report calling for reparations, the state of Oklahoma refused to pay the reparations. For 2 years, they refused, and that prompted a lawsuit being filed by the Reparations Coordinating Committee, which I was a proud member of. And my good friend, Professor Eric Miller, is a very prominent member of the Reparations Coordinating Committee. And many of these individuals you see on the wall are plaintiffs in that case. That case was dismissed by the federal courts in 2005. So the federal courts failed us in 2005. And so we then went to Congress and we worked with the great late Representative John Conyers and Representative Maxine Waters, Representative Sheila Jackson Lee, and many others to get legislation introduced in 2007. And we had a hearing in 2007 on that legislation to make it easier for these survivors to bring a lawsuit. But that legislation failed. And we reintroduced it every year, 2008, 2009, 2010, 2011, 2012, 2013, 2014. And each year it failed. So the Congress has failed these survivors and Mother Randall, Mother Fletcher. And so we filed this litigation that we're here talking about today in 2020, September 1, 2020. And yet, once again, the court system has failed the survivors, descendants, and the Greenville community, and failed all of Black America who wants to believe in this country's principles, that there is equality underneath the law. But we have not seen that as it relates to the 1921 Tulsa Race Massacre. Mother Randall, in 103 years of suffering from the experience of the massacre, has not seen justice or equality underneath the law. You know, just 3 years ago, right in this very room, my clients, Mother Randall, Uncle Red, and Mother Fletcher, met with President Joe Biden. He sat down with my clients. He promised them that he would see that they get justice. And then he went out to the next room and had a robust speech where he told the nation that he stood with the survivors and descendants of the Tulsa Race Massacre. Well, now that we have been failed by the courts, now that we've been failed by the Congress, we're calling upon President Biden to fulfill his promise to these survivors, to this community, and for Black people throughout this nation. We hurt for the survivors. We hurt for the descendants. We hurt as a community, a national Black community, for the destruction of Greenwood. And as you will hear from Mother Randall's statement, she's here at 109 asking for the President of the United States to stand with her, for the Department of Justice to come in and stand with her, to open up the investigation pursuant to the Emmett Till Cold Case Act. We have been begging them to do this for years. We've had multiple meetings, multiple Zoom meetings. We went in person. We've had multiple letters. It is time in this election year. It is time for the administration to show not just Mother Randall, not just this Greenville community, but Black America, that they will stand with us in our time of need, that they understand our pain and the pain for our people throughout this nation, to know that a horror can happen so devastating that it destroy and alter the entire trajectory of Black people throughout this whole country. And yet we can have a living survivor and she can't even get a day in court. So while we have filed a petition for rehearing that my colleagues, my teammates, my friends, my co-counsel will talk more about. Make no mistake about it. We understand that the only thing that can help Mother Randall, this community, and Black people's trust and belief in this system is for the administration to step in, come stand with Mother Randall, and ensure she gets justice that she deserves. She's waiting. She's making the call. She remembers the meeting with the president. She remembers the promise that was made. She wants it to come to fruition. I ask Mackenzie, if you would please come and read Mother Fletcher, Mother Randall's statement about this. Thank you.
Good morning. I have the profound privilege of reading a statement last two living survivors of this massacre. It is 2024, 103 years after the Tulsa Race Massacre, and our legal system continues to deny Black Americans an equal opportunity to seek justice under the law. The reality is as simple as it is chilling. We, the last two survivors of the Tulsa Race Massacre, have been forced to jump over higher legal bars than anyone else, simply because we dare to seek justice for the atrocities committed upon us and our community. We are profoundly disappointed by the Oklahoma Supreme Court decision to reject our lawsuit, and we are deeply saddened that we may not live long enough to see the state of Oklahoma or the United States of America honestly confront and right the wrongs of one of the darkest days of American history. At 109 and 110 years old, we are weary, and we know that we are living on borrowed time. Because of this, we have decided to use this statement to speak boldly and straightforwardly about the failures of the American justice system to all who will listen, for we have nothing left to lose. Oklahoma and the United States of America have failed its Black citizens. This failure is profound, systemic, and marred by lip service and clever platitudes. With our own eyes and burned deeply into our memories, we watched white Americans destroy, kill, and loot. And despite these obvious crimes against humanity, not one indictment was issued. Most insurance claims remain unpaid or were paid for only pennies on the dollar. And Black Tulsans were forced to leave their homes and live in fear. This is the American reality. No matter how much politicians seek to instill policies that hide our history, this is our collective truth. It seems that the only justice permitted for Black Americans are sympathetic words and supposed promises that white Americans, our government, and our justice system will do better. But the lip service continues, and tangible justice is consistently denied. Notwithstanding the obvious crimes committed upon Black Americans during the Tulsa Race Massacre, we are asked to continue to keep our faith in the American justice system and keep waiting for things to get better. We're tired. Although our quest for justice in Oklahoma may be over, for as long as we remain in this lifetime, we will continue to shine a light on the darkest days of American history. But we know that there is more that can be done. And we ask the United States Department of Justice to intervene and open an investigation into the massacre and do what Oklahoma has never done. It is not too late to do the right thing. We want to deeply believe in the government's power to do right by Black people and to focus its power and attention on righting the wrong inflicted on our communities. Although we are deeply disheartened with the court's ruling, we remain women of deep faith and trust that one day this country will do the right thing for Greenwood and all Black. We just hope that we are around.
Thank you. Yeah, I want to- Next, we have Eric Miller, petition for public.
In 1921, the city of Tulsa, county of Tulsa, state of Oklahoma, the Tulsa Chamber of Commerce engaged in a criminal conspiracy to destroy the property of 10,000 residents. And yet, as we heard from my colleague and friend, Mario Simmons, in 1921, the victims of that massacre were denied the opportunity to have their case litigated in court. In 2003, the federal court acknowledged that the state of Oklahoma had prevented the survivors from getting access to justice in court, but said this court will also deny them justice. And in 2024, the Oklahoma Supreme Court acknowledged that the courts in 1921 and again in 2003 had closed their doors and said, we will close our doors too. Courts in Oklahoma have consistently refused to grant justice to the survivors of, again, one of the worst criminal terroristic conspiracies in American history, by continually saying, we are not going to open our doors to give you a hearing on the merits. In fact, the Oklahoma Supreme Court rewrote its own public nuisance statute to prevent the last two living survivors getting a hearing on the merits. The court acknowledged that under traditional public nuisance pleading standards, we had demonstrated that the city of Tulsa, the county of Tulsa, the Chamber of Commerce, the state of Oklahoma had blighted property, and that traditionally, blighting property entitles the victims to a remedy. But then, and the court acknowledged that Mother Randall and Mother Fletcher are currently impacted by the defendants, including the city of Tulsa's actions in blighting that property. But then the court's reasoning falls apart. The court ignored 107-year-old precedents to say both that we can show any impact, but that the impact is too great for courts to remedy. The court makes up facts and claims that don't exist in the complaint to justify their dismissal. The court said the hearing was historic, and it certainly was. It was an historic act of cowardice by the Supreme Court in refusing to grant a hearing on the merits. Our petition for rehearing is important because it lays out precisely the ways that the courts have overturned its precedent and misrepresented our arguments to continue its century-long tradition of denying justice to the victims of a race massacre.
Thank you, Eric. Everyone should have a copy of our petition for rehearing. And now you're going to hear from Randall Adams to talk about our second claim within this lawsuit, which is the unjust enrichment claim, which is also unfairly dismissed.
So the unjust enrichment claim, I think, is a very clear example of the goalposts being moved throughout this litigation, and standards being applied to Mother Randall and Mother Fletcher, which are not applied to other litigants in Oklahoma. So for decades, the standard for unjust enrichment is any condition which results from the failure of a party to make restitutions in circumstances in which it is inequitable and a party has in its hands money, inequity, and good conscience, which should not be allowed to retain. And so our unjust enrichment claim arises from the fact that the city of Tulsa and the other defendants have raised tens of millions of dollars for cultural tourism, none of which has been shared with Mother Randall, Mother Fletcher, Uncle Red, or any other members of the descendant community. So we alleged that this had happened in the complaint, and as you know, it meets the definition that I just read pretty fairly. So through the course of the litigation, the defendants pointed out they thought certain paragraphs in the complaint didn't really apply. We said, okay, fine, we'll take those out. Let's just get to the trial. Let's just get to the trial. When Judge Wall dismissed the claim in 2023, she said nothing about the unjust enrichment claim. So we were never even told what the basis was to dismiss this claim. It truly was completely silent on the unjust enrichment claim. And the other part of pleading standards is that you generally get a chance to correct the pleading. So the court says, okay, you haven't quite made this pleading standard. This is what's missing. If you can plead that, and we'll get to the trial. We were never even told what the defect was. So then 2 weeks ago, the Supreme Court tells us that the problem with our unjust enrichment claim is that we haven't alleged fraud, abuse of confidence, or unconscionable conduct. This has never been a required element of an unjust enrichment claim. This is new law that the Supreme Court is making up in this decision. And the Supreme Court goes on to say, for example, you didn't allege that when the defendants were raising all this money, they created the impression that Mother Randall and Mother Fletcher would be the beneficiaries. You didn't allege that. Well, first of all, we didn't know we had to allege that because it wasn't an element. And second of all, we can absolutely allege that. The defendants did create that impression that Mother Randall and Mother Fletcher were going to be the beneficiaries of all this fundraising. So at a minimum, the Supreme Court should have permitted us the opportunity to amend the pleadings to add in this allegation, which we absolutely can't make. So that's what we're seeing in our petition for rehearing. If you think that this is an element, you're the Supreme Court, you're deciding what the law is, you're adding an element to an unjust enrichment claim. If that's the case, give us the chance to replead this. And we weren't given that chance, and the Supreme Court, if it does the right thing and applies the law correctly, it will give us a chance to replete it, because as I mentioned, we can't absolutely include that element. And so as I'm just saying, this is an example of a case where we didn't find out why this claim was dismissed until the end. And we were never told what the defect was in time for us to correct it. So the Supreme Court should change its mind on that.
Kind of depressing to hear that, but we wanted to make it real plain and clear to all of the adherents of the nation that again these goalposts continue to be moved, and that's again why we said we need the federal government, we need the Biden-Harris administration to come in and make this right. Next, you're going to hear from another one of our co-counsels, Sarah Salpanelli, also with Shelty Roth today.
As you've heard already, the Oklahoma courts have failed us so far. The Oklahoma courts, the federal court, the legislature, they failed this community for far too long, in far too many ways, for far too many decades. But we stand here, and we have to hold on to the belief that Reverend Martin Luther King has told us that the arc of the moral universe is long, but it will bend toward justice. Now, my close friend and co-counsel Meyer did remind me this morning that arc will bend, but it needs to be pushed. You need to push it to bend. And as the words of the Talmud say, you are not obligated to complete this work, but neither are you free to abandon it. Schulte Roth and Gable, our firm, is deeply committed to using our resources, our financial, our human resources, to continue this fight for justice for Greenwood. We are not going anywhere. We are not leaving any stone unturned. We will push on to advocate for justice for Greenwood. And I ask all of you here today and everyone watching, I challenge you to do the same, to use your resources, your voice, your platform to continue to push that arc, to bend that toward justice for Greenwood. It is all of our collective moral responsibility and obligation to continue the work, to continue this fight. All of us as co-counsel, us as a law firm, all of you here, all of you listening, and to the government, to the U.S. Department of Justice, do the right thing.
Thank you, Sarah. before you hear from our last speaker, Dr. Crutchell, I just want to acknowledge, as you see in our petition for e-hearing, we have a very robust legal team. Everyone can be here. I don't want to start naming everyone's name, but I do want to name one person, John Knott. She's over in Oklahoma City. She couldn't make it, but she's been instrumental in this appeal process. And we really appreciate her, as all our co-counsel who've been involved in this process for over 4 years. You heard from all the lawyers. We asked Dr. Crutchett to speak as a descendant and also someone that is a partner with us in this work and someone who's deeply invested in this community. What this means, this position review, and just moving forward, what does it mean for us as a community?
Well, first, let me just say, as a direct descendant, I'm so grateful for Mother Randall and her granddaughter and Uncle Red's granddaughter, who continues to show up in spite of the tragic loss of Uncle Red on last October. So I just want to personally say thank you to the community, to the descendants, to the advocates who stood with us, as Mario said, over the past 4 years. We need you to continue to stand with us. And DeMario, he stated it just right. Right here in this very room, the 46th president of the United States of America met with the 3 last known living survivors. And it was on this sacred ground, right next door, that he said these words, and I quote, "For much too long, the history of what happened here was told in silence, cloaked in darkness. But just because history is silent, it doesn't mean that it did not take place. While darkness can hide much, it erases nothing. Some injustices are so heinous, so horrific, so egregious, they can't be buried no matter how hard people try. No matter how hard people try. So here it is. Only with truth can come healing, justice, and repair. Facing it. Facing it. Facing it. But that isn't enough, the 46th president said. First, we have to see, hear, and give respect to Mother Randall, Mother Fletcher, Mr. Van Ellis, and to those lost so many years ago, to all the descendants who suffered into this community. I agree 100% with President Biden. We must face it, and we must give respect to our survivors, the descendants in this community, by demanding that the Department of Justice immediately investigate what happened here on this sacred ground over 100 years ago. This community is watching, President Biden. This nation is watching. History is watching. And the very survivors who are depicted on this wall are crying out from the soil for peace. For peace. And this administration has the power to help them rest in peace. So we look forward to a swift decision. And as Mother Randall and the survivor stated, we have nothing to lose. Thank you.
We thank everyone for coming out. We talked about the people on the wall who were clients of Eric and I, who are now all deceased. You know, Eric would tell you, you talk to them, they would always say, I want to see justice in my lifetime, but not just for me, for my children, my grandchildren, for this country. I always thought, I know Mother Randall and Mother Fletcher feel the same way, that if they survive the worst domestic terrorism in the history of this country, can't see just, what does that say for the country? What does that say for Black people throughout this land? And as we are getting into this election season, and people are questioning why should they stand in line and vote, people are questioning does it matter?
People are questioning when things change. This singular issue could be the difference between us continuing to have a democracy and a total dictatorship. Because if the administration would show that they care about these survivors' pain and they care about Black Americans' collective pain by having such an open wound, the Tulsa Race Massacre not be rectified, and not fair for this country. Thank you.